know, in 3 days sign the contract?
Oh, I believe 3 days gone already. The 3 days mean right after the purchase agreement was signed by both parties, and the seller in California, seller must provide a property disclosure statement to the buyer. When buyer receive it, either 3 days or 5 days, buyer can make a decision whether or not to keep the contract. So after your loan being approved, I think these 3 days the loan gone already.
But I think I remember they have to sign the loan documentation. Even you sign the loan documentation, you still have 3 days.
No, 3 days loan does not apply to the purchase.
Oh,
Because if you apply to the purchase, it's gonna become a chaos.
Okay.
So right, the loan 3 days is provided by the law, but not the purchase loan, refinance loan. Yeah, because refinance you will not affect the seller.
Just have an extension for the example. Say if both sides agree to buy sell the house, right? And then the buyer say, but the buyer say if he changed his mind and he don't want to buy it anymore, can he use the say the loan unqualified as an excuse?
Yeah, this is a very good point. Okay, this is a very good point. Let's talk about this. Say you are the buyer. For example, you are the buyer. In your mind, you just change your mind, but you don't tell anybody. Nobody knows, right? Nobody knows. However, your loan is on the border. Your loan application is right at the border. Could be approved, could be denied, and you just refuse to provide your true documentation. Say the lender say, you need to provide the current paycheck stub. And you just don't cooperate. You just refuse to pay it. So of course your loan turned down. Your loan be denied, right? And then you use this as one good reason because you have the denied letter from the lender. You just show this to the seller. Say, okay, my loan was denied, so I want to cancel this. Well, assuming there's no any discovery. One more time, I always want to say that the law is the minimum, it's not the maximum, okay? Even though I'm a law student, I never think, sorry about that, I just don't agree with my very old professor. In Taiwan, my old professor say the legal is highest one, the most beautiful one. No, I don't think so, okay? It's a very ugly one, by the way. It's a very ugly one. I believe at that moment, 30 years ago in Taiwan, because in Taiwan it's not really legal systems, legal society is. I believe my professor want to pursue a legal system society. So professor would like to say, okay, we pursue the legal by law society. I think I can understand. But again, other than that, I think law is the minimum. Discovery means if there's a lawsuit happen, the seller can ask the buyer to turn everything out. And the seller maybe find out the real reason for the term being turned down because the buyer did not cooperate. Then the buyer will still be obligated. You understand? But there's a true reason if the loan being turned down is really legitimate. Even though buyer feels so happy because I just want to cancel and it happened to me, then it's okay. Because the thing happened legitimately 100% match what you think, there's nothing wrong. Nothing wrong. But you cannot just use this one as excuse and you don't cooperate with the lender and you intentionally to have your loan application turned down, then the buyer will still be obligated.
So my question is whether the seller can have the right to pursue.
Yes, of course. I saw a lot of the cases the seller will not let the buyer go. You can imagine today's market, especially bank-owned market, right? The bank-owned property, they've been hustled so long already, and finally you are the buyer. You want to buy this property from the bank, and the bank so already give a very good deal, and for any reason you just change your mind. You just change your mind. Of course, usually bank will not let you go, and they have their lawyer. They will not let you go. So Yes.
I'm curious about one scenario. So what if A lends an apartment to B and rents an apartment to B?
So A is landlord, right?
A is the landlord.
Landlord.
And
B is a tenant.
B is tenant.
Okay.
And B, for whatever reason, died.
Okay.
And is B's family or children, are B's family and children liable for this contract?
Very good questions. Let's talk about this. Let's talk about this. What issue you think? It is part 1 issue, formation, or part 2 issue, discharge, or part 3 issue, damages? Let me repeat her question one more time. Very good questions. A is the landlord. And for example, sign off 1 year lease. And every month 2,000 per month rent. Okay? Starting from January 1st till the end of December, the whole year. Okay? So 2,000 per month. And once tenant move in, and 2 or 3 months after, tenant just pass away. Assuming no any other criminal issue, okay? Assuming just a very simple civil issue. And her question is whether or not tenant's family or tenant's children be liable to pay for the remaining rent. Very good questions. So what's your feel? How do you feel? You need to answer, okay? Of course, this is not part 1 issue for sure, right? This is not part 1 issue because there's no any defect on the agreement by itself. Part 2 issue, whether or not that gonna affect the liability or obligation.
No, I think that's the contract told it.
So this is one opinion say that by itself will terminate the remaining 9 months, 10 months. How about the other?
If that person living alone, the children or did not live together.
No, for simplify, single person.
Yeah.
A single person.
Single
I
person.
think the contract is between A and B. If B pass away, I think the contract is no longer hold. Because
Any
A
other
hold that
opinion? Any other opinion?
I think that B present his family, so his family have to still.
Okay, let me tell you what. Okay. Yes, go ahead.
So if
Go ahead.
the child is under 18, then the
No, B is more than 18. How about that?
No,
The
you're
child.
saying the child.
Family.
The child is under 18.
How about another answer? Any other thought? Any other thought? Let me give you the answer, okay? This is the answer. Let me tell you what, okay? The reason why you got confused and also try to avoid this confusion. When you do any analysis, be careful your analysis. The reason why you got confused here because you combined 2 unrelated issues here. Don't mess up, okay? There are 2 issues, they are not related at all, but you combine it together. Don't do it. One is whether or not death affect the contract. The other issue is whether or not B's heirs will be responsible for the lease. You confuse it. You do not involve B's heirs coming in, then your analysis become a lot easier. You understand? Understand? Let me say it again. In this case, your discussion will not cover B's family or B's children or B's any legal heirs. Then your answer become a lot clearer. Understand? Because your answer becomes so blurred, so messy, because you combine those 2 issues together. You shouldn't do that. Let me answer you, okay? B's family or B's children or B's heirs will not be responsible for B's debt. Making sure, okay? Then you start to analyze whether or not B's debt will affect the rental agreement. The answer is no. The answer is no. B's debt will not affect this agreement. Let me change the scenario. If B is still alive, for any reason, B will was relocated to Europe for 6 months. Do you think B can terminate the lease?
No.
No, of course. So if on vacation, if on the travel, cannot relieve B from his payment, why that, right? Of course, your analysis, well, B can no longer use, but why should A as a landlord got lost, right? Because it will become A's burden to find out another tenant. Not only that, probably A is bound by the lease. If the lease is not expired, A is not allowed to rent to anybody else. Understand? So it doesn't matter B use it or not, B's debt will not affect the lease. But what's the result? You're gonna ask me. Well, it's deadlock, right? It's dead end. If B cannot use it and B's heirs is not responsible, and how is A get compensated? Again, go back to the issue we talked about probate. This case will go to the probate. Okay. Probate. One person passes away. If there's no living trust, no will, even with will, the case will go to the probate. And the judge and the court will publish this news on the newspaper. And I think landlord, for some reason, must find out B passed away. So there is a time limit. So I think this is a 4 months period. Okay, 4 months period from the publication. Any creditor, not only landlord, any creditor can submit their right or claim to the court, to judge. Say this person passed away, but still owe me certain money. So it doesn't matter B cannot use it or not. Still, B is still liable under the lease agreement to pay for the rent. I know, unfair, but this is the solution. This is the solution. Maybe, the person represent B can file the motion to ask the judge, see, can judge approve the terminate the lease agreement. There may be another solution. Or say, I represent B to find out another tenant coming in to sublease. A lot of solution could be, but by itself, number one, do not involve B's heirs coming in. B's heir is not responsible for B's debt. Number two, B's debt will not affect the lease agreement. Yes?
If the same question